Court will next take up the case of Kim Valdes versus Robert Valdes.
I'm Dan O'Connell. I represent the appellant Kim Valdes. Mr. John Nettles represents the appellee Robert Valdes. This case is a classic example of someone being shortchanged. There are not specific findings in the record or the final judgment to see whether or not a reasonable man test has been satisfied, but the Florida law provides that absent specific findings, the judgment must be reversed.
Well, in part what we have here is we have like two different appraisals for the business property, correct?
No, sir. You have two different appraisals with the exception that neither one includes goodwill. The owner, who was the wife, as well as the husband being the co-owner, testified $400 that this was a business in Newberry, the main intersection. It had been in existence for 20 years. It's an enterprise goodwill, and he omitted it. The second district in Parker versus Parker is saying that an omission is the equivalent of lack of substantial competent evidence, and that's what we have here.
So you're saying there has to be goodwill?
Yes, sir.
I mean, the trial judge isn't free to listen to the wife's testimony as to what she thinks the goodwill value is and reject it?
That could certainly be within the court's province below, but he didn't say that.
He has to say everything he decides?
Yes, sir.
And he has how and why?
That's something that's significant. Yes, that's the only evidence in the record. She is qualified as an owner. It is an appropriate enterprise for the same to have been considered. If the court rejected it, then it should have said that so that I wouldn't be here before you guessing as to how he shortchanged my client, but rather just simply knowing that he did. And the other thing is that the Lafayette Bank appraisal was done contemporaneously with, and in fact was the appraisal upon which the loan proceeds were loaned to the parties.
Well, you just think that that's better evidence, right?
Yes, sir, and it's
But the judge gets to decide what's, I mean, the fact finder in this case is the judge gets to decide what evidence is better evidence.
Well, that begs a problem here, Your Honor, and that problem is that these two people committed themselves to this enterprise. They borrow the money based on this appraisal. That's the amount that's owed, and then they bring in somebody else who testifies, oh, it's $425,000 less. But either way, the enterprise itself was not properly valued, nor was it explained why it wasn't. And another premise here that leads to the confusion and the shortchanging of the appellant is she is the owner of these properties. And throughout this final judgment, the trial court is saying, well, the husband paid it from the business, and the husband was the business. And that's just not the
Well,
fact.
the parties kind of ran their life a little bit that way. They got their gas from the pumps there, and I think the testimony was they said that the business paid for their car payments. I mean, that's the way they refer to things. And so it's not shocking that the judge would use the same terminology that they use.
No, it's not shocking, but that doesn't make it correct, Your Honor. And the husband was an employee of the LLC. He was not merely the proprietor. So, as we go along, and all these monies that we're paying down, mortgage balances and consulting fees and stuff that were credited to him in the final judgment were being paid with the wife's own money.
How about the judge talked about that he did that with his salary from the business?
In the transcripts, I've got the one page there, the husband goes on to say, well, that's how I perceived it. We repeatedly said to the court, and the records show that it was a joint enterprise, but he perceived it as though whenever he wrote was his salary. And it would have been, the wife ended up paying taxes on certain distributions that were made to her, which the husband summarily decided not to take. And so it was a little bit lopsided in that regard, and that's in the record as well. And then the other problem, cutting to the third issue, if the court please, on the child support, We had a situation where he doesn't tell us what the income is. He doesn't tell us how he calculated it. Guideline support calculations were submitted by the appellant, and there's no reference to them. And certainly the Florida courts have recognized that's reversible as well. There is a typo in the appellant's initial brief. I think it makes reference to health insurance. That was supposed to make under issue 3 reference to life insurance. And there's no finding nor rejection as to why the former husband wasn't required to follow up his obligation.
Well, there is
The
obligation.
statute requires
Yes,
the former husband to purchase life insurance.
It doesn't require it, but it should be reviewed and asked why it isn't being required.
So all the fact finding that the trial judge is required to do if he orders life insurance to protect and award child support or alimony, you're saying that realistically that really means that he has to make the same kind of fact finding when he decides it's not necessary.
Possibly. All right. I think that certainly it would be appropriate as to why it shouldn't be required. I'd like to reserve the rest of the time for anything in rebuttal unless the court has any questions
Counsel.
at this time. Yes, sir.
Have you identified which assets or values were left out of the trial court's order?
Yes, sir. There's no reference to goodwill, and on page 229 of the record, the appellant testified, it was $400,000. This business has been here for 20 years. They own Lucky 7 LLC. It had been the husband's father's business, and it's a separate enterprise. It has nothing to do with the appellee, Robert Valdes, or his personality or anything like that. It is the most trafficked intersection in Newberry, Florida. And if you look on page 172 of the record, the business plan, which was drafted by the parties, and it says location is our strongest point. And the wife repeatedly tried to emphasize to the court that she did all the research on getting this car wash in there.
I'm confused as to why location is goodwill. I mean, clearly
No, sir,
location
no,
of
sir.
a business would obviously be important for almost any business, but
What I'm saying is location gets it away from the personal makeup of the individual that may be running the enterprise.
But I mean, maybe the unlucky 7 on the same corner would do the same business. I mean,
Exactly. But it might be the corner, and it also may be 20 years of a small community doing business with Lucky 7.
but if you want the trial judge to find goodwill value, I mean, isn't it your burden to convince him that in fact that value exists and present evidence that he
Clearly.
finds persuasive?
Clearly, and on page 229 of the transcript, the appellant testifies it's $400,000 based upon 20 years of our being there and the type of enterprise that it is. And there is no other testimony whatsoever. So that's it. That should.
Well, he doesn't have to accept unrebutted
But
testimony.
he didn't tell us he didn't. How do we know he didn't just omit it or space it out or miss it? And that's why we're here today, is to ask you to send it back and say, please look at this. This is a sizable portion of the marital estate, and it's not a...
You're client, an expert witness in business valuation?
No, sir, but she's the owner of the...
And is an owner competent to testify?
Yes, sir.
Goodwill value?
Yes, sir. There's one case that starts with an HP, and I can't pronounce it, but it's cited in the brief.
All right.
I'll reserve the rest. Yes, sir.
There was a live witness, Mr. Emerson testified on behalf of the husband, right? In terms of appraisal.
Yes, sir. Now, Mr. Emerson's appraisal does not include a reference to goodwill, and it's not included in his appraisal, and that's in the transcript as well as in his appraisal in the exhibits.
Well, wasn't the trial court free to accept the live testimony of the expert witness?
But they didn't make reference to the goodwill issue. And if he said, I'm going to find that the Emerson appraisal is more valuable in terms of its credibility to the court for evidentiary reasons, that would be one thing. There's not even a comparison.
Why don't we adopt a rule? Couldn't we always say that the trial judge could have said something else, that he could have explained one more thing just a little bit clearer, and that would have helped the party understand why they didn't get exactly what they wanted?
Sure you could.
And
But-
then we would be reversing all these cases all the time. wouldn't we?
No, sir. If you make specific findings as the statute mandates, you don't have this problem. And if he made a specific finding, possibly we wouldn't have grounds to be before this court.
And you move for rehearing to clarify that?
Clearly, and he had it under advisement for some time, and the rehearing motion and the order denying it is in the record.
But I mean, the testimony is from the husband, this is the whole value of the business. And the testimony from the wife is, well, look, we went to the bank and the bank came up with this value and I would add $400,000 onto it. And he accepts that value. Your position is that he has to then say, and I reject the bank's value, I reject the wife's value. Does he have to explain why he rejects it, or is it I reject it?
Well,
Because clearly you can.
yes, sir, and following that thought is he gave the husband the business, the LLC. If he just given him the property, again, that wouldn't be a problem because the wife would still be the owner. And plus, some of these properties had rental income on them, which were not included in the calculations or possibly
Didn't
not.
Mr. Emerson explain
Yes, sir.
the differences in his valuations than those of the bank appraisal?
The difference between, I'm sorry,
His valuations than those in the Lafayette Bank appraisal.
there's $425,000 difference between those two.
And did he explain his differences, why they exist?
He presented testimony to that effect, yes, sir. Thank you.
May it please the court, I'm Jack Nettles. I represent the husband in this case. Taking the last thing I heard first, Mr. Emerson does address the difference between Silverman appraisal and his appraisal very specifically in his testimony. He speaks about the depreciation that Silverman showed for the business, which was $67,000. His depreciation was $295,000. He speaks about the land value. Silverman felt the land was worth $700,000, and Emerson thought it was worth $420,000. So there lies most of the difference between the two appraisals. The Silverman appraisal was actually conducted 6 months after the valuation date, after the filing of the divorce, after the car wash had already been constructed. It only placed a real property value on parcel A. There's parcel A and parcel B. Parcel A contains the car wash, the mini market, which has a little beauty salon in it. Parcel B is some other real property that has a little liquor store about the size of River Stand. So the only appraisal that was conducted on the valuation day was the Emerson appraisal. And it was for both parcels, and it separated out as directed by the previous judge, Judge Genta. Judge Genta had made notes in the court file, and Judge Glanton, who's the trial judge, noted that the parties had agreed that both appraisals would come into evidence. So counsel for the wife was already anticipating using real property appraisals leading up to the time of the trial because it had been agreed upon these two real property appraisals were coming in.
And the judge isn't free to average those appraisals out, is he?
No, sir, there's a case very specifically on that point.
Let me ask you about, how did the trial judge determine the child support?
Your Honor, he left it where the parties had set it based on guidelines early on in the case. The husband had paid $100 weekly towards the support of the child through.
Did either party file any child support worksheets?
No, sir, we have no child support guidelines in the record on appeal. I went through and, of course, I wanted, if there were such things, to have them sent up here. They weren't.
So, I mean, if we look at the financial affidavits and we determine that the guideline child support would be more than the $433 a month that $100 a week equals, is that reversible error on the trial judge's part?
Your Honor, the trial court has discretion in that area. I think that you have to look at, when you walk into a trial as an attorney, what you have to do. You have to present an argument to the trial judge to be able to bring it before the appellate court and complain about it. If you go before the trial court and you don't bring up the fine points of child support in a guideline showing tax deductions, health insurance payments, if you don't reduce that, you don't argue it at the lower trial court. You can't expect to be able to bring it up here and have the appellate court sort it out. It's kind of like in the counsel's choice not to have an actual CDA do a business valuation.
Did the party
of the case.
stipulate to $100 a month child support then? Is that
They
true?
had been operating under that for the entire pending, the case was pending from June of 06 until the trial date, Your Honor.
So the parties agreed to a temporary child support of $400. Is the trial judge free just to continue the temporary child support without evidence?
He wasn't provided with any additional argument on the amount or the child support calculation. I would say that when I look at this, I'm aware that the court has ongoing jurisdiction to view child support at any time. One could have asked your court, the DCI, to relinquish jurisdiction to the trial court for that purpose at any time that counsel recognized that child support was not the appropriate amount.
So
Did
this
you
was
get back to your business valuation points you were just getting ready to make?
Yes, sir.
You had mentioned the business valuation expert testimony.
Yes, sir. I didn't complete that. No, thank you. I was discussing how the valuations were different. And one is that Emerson recognized that the convenience store was built in 1976. It was 30 years old. The pumps had been installed in 1993. They were 13 years old. And Emerson recognized that the normal life for mini mart is about 50 years. So when Silverman only allowed $67,000 in depreciation, Emerson said no, $295 would be more appropriate. And the judge, by the entry of his order and by placing the numbers that he did place in the order, accepted the Emerson.
What about your
price.
opposing counsel's argument that the judge had to make some kind of decision regarding goodwill?
Well, once again, there's case law cited in the briefs that talks about how you have to present and argue your case at trial.
Well, he presented the wife's testimonies.
About $400,000. To make a finding on goodwill, you need to separate it out as a practice goodwill, a personal goodwill. Who knows if Mr. Valdes had left and bought the station across the street, all the goodwill would have gone with just him individually. It does take an expert CDA to determine whether practice or practice goodwill attaches to a business. This was not done here, but that was counsel's own decision not to bring forth the CDA and that information right up to the day of trial. He argues in two places in the transcript.
So you would concede if the opposing counsel had brought forth a business expert on goodwill, presented that testimony, and the trial judge just makes no finding whatsoever, doesn't say I reject it, doesn't, just did the exact same order he did here, would the opposing counsel's point be well taken?
I believe that had the court been submitted with the information, that the court would have had to said who they believe.
Well, then that gets back to my question of your opposing counsel. Was the wife's testimony adequate to require us to hold that the trial court had to at least tell us, I reject the wife's testimony about goodwill? I mean, he didn't have to necessarily, I understand we're getting into the minutiae here as to what a trial judge has to say, but to say, the wife presented testimony regarding goodwill. I find no goodwill was established. We just assume he doesn't address it.
The testimony in the very, very last, almost last page of the brief as a rebuttal. The judge, in rejecting that testimony, not including it in his order, made it very clear he was accepting not only the Emerson appraisal, but he was accepting the CPA, Dean Poole's assessment of what the business debt was, and what the actual net value of the business was. That is all in the order. It's very carefully set out. So it is apparent from the order that the judge intended an equal and equitable distribution, leaving the parties evenly situate as far as value, and he placed his ruling very clearly in the order, very specifically. I wanted to add that that most of what you see in the final judgment was stipulated to in the proceeding. For example, The amount of debt was agreed upon. There's a point in the transcript where that's agreed upon. The value and the division of the personal property was agreed upon. The value of the marital home and the equity in the home was stipulated and agreed upon. So what does a judge have to do when 80% of the case is agreed upon and he's got one issue to decide? Do I accept the Emerson appraisal or do I accept the Silverman appraisal? I think he set out very specifically what his financial findings were in order based on the evidence that came before him. And can counsel just not bring evidence before the court and have an automatic ability to go to appeal and have the case reversed and get fees for that if the counsel intentionally does not bring forth evidence at the trial level? And that, in fact, is what was done here. The evidence all came from the husband's side. It's very analytical. There are summaries. There are supporting documents for all the credit card bills, all the money that the wife was checked down to the penny, paid by check down to the penny. And the court was able to provide credits to the husband for paying some $40,000 to the wife during the separation.
So if we find that the trial judge doesn't have to answer every question the party might have looking at his order later, and the parties here have fairly equal income. Actually, I think the wife has about 58%, your client's 42%.
Yes, sir.
Something like that. But does that mean that she should pay attorney's fees to your client?
Your Honor, it was not the husband that chose to appeal this case. I don't believe either of these parties are in a position to pay fees or really be arguing at this level. I don't, but I guess technically speaking, he would be the prevailing party. I don't know how much actually what a trial judge would do with this if it was provisionally granted back to Gilchrist to set some fees. I think he still goes back and looks at what the party's ability to pay this fees. I don't think either party really has a lot of ability. Certainly mine. Thank you very much.
May it please the court, I'd be happy to entertain any questions anyone may have, and if not, I'll just conclude by, again, emphasizing the statute requires specific findings. The case that deals with omissions is that Harper case out of the second DCA, which we cited in our supplemental authority. And it just basically says, gave no reason for the omission. Thank you very much.
Thank you. The court will next hear the case of Allstate Property versus Debbie Lewis. Counsel ready to proceed?
My name is Kate Anderson. I'm here with Kansas Gooden, my associate. We represent the appellant of Allstate Property and Casualty Insurance Company. I'd like to note for the record first that both Kansas and I have changed law firms in the past couple of weeks. We are now with the law firm of Boyd Generett in Florida. The issue in this case is whether the trial judge erred in granting a motion for a new trial filed by plaintiffs in the underlying case. It is Allstate's position that the trial judge used his discretion in ordering a new trial for several reasons. The first reason is that pursuant to the controlling case law on this issue, in particular the Supreme Court case of Binger.
Was Binger argued below?
Pardon?
Was Binger argued below?
Yes. I believe so, although the trial judge in his order references Suarez-Burgos as the controlling case. But pursuing to Binger and Suarez-Burgos, what the underlying plaintiff was required to show is that the testimony of Allstate's expert, Dr. Von Braun, amounted to unfair prejudice and surprise to
Did
the
he change his opinions?
No, he did not.
What were his opinions?
His opinions were that the plaintiff did not suffer an annular tear, and that he went through the medical records. He noted some prior back
What
treatment.
about where he testified that he would defer to the radiologist? What's that mean?
What that means is that, number one, that's not an opinion of anything. That's just an honest answer from a professional, which was to the effect that, yes, I am qualified to read MRIs, but I will defer to a radiologist who does this all the time. This is exactly what the plaintiff's own neurologist testified to earlier in the trial.
Did he testify that there could have been a tear that pre-existed the car accident?
Dr. Von Braun? No. I have been over this transcript word by word, and I have not found any such testimony. He maintained and reiterated throughout all of the direct, cross, redirect, recross, that he did not see an annular tear. In fact, on cross, he was apparently looking at the actual MRI.
Right.
He explained to the jury, this is why I don't see the connection. There's no connection between the fluid and the place where the annular tear supposedly is. He was very clear about that, explained that to the jury, reiterated that, yes, I would defer to a radiologist.
What about the violation of the motion of limine? Didn't the trial judge make a finding that the motion of limine was violated?
I think that the judge did make that finding, but I can't find any place where the motion was violated. He never changed his opinion. He never testified outside of his report. One of the big issues apparently was that Dr. Von Braun testified as to Dr. Paco's report, so I believe was the chiropractor. Dr. Von Braun references that in his report. And even prior to the beginning of the trial, this was discussed with the trial judge, and Mr. Cohen admitted that he had made a mistake in making that representation to the court.
Counsel, assuming the